Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning, everyone. Please be seated. We are here this morning for 2 oral arguments and a third argument. Iowa Supreme Court Attorney Disciplinary Board versus Joel Fenton is hereby submitted without oral argument. So we will begin the morning with State versus Miller, and it looks like the parties are ready. Ms. Newell, you may begin.
May it please the court, counsel. My name is Ella Newell, and I represent the appellant Willard Miller. Mr. Miller requests this court vacate his sentence and remand his case to the lower court for a new sentencing hearing. Juveniles are constitutionally different from adults. Throughout the Miller, Lyle, Roby, and other case law addressing juvenile sentencing hearings, both federally and in Iowa, there are a series of presumptions that underline the procedure to comport with the 8th Amendment of the United States Constitution, as well as Article 1, Section 17 of the Iowa Constitution.
The meat of the matter here. It seems like you are focused on the importance of expert testimony. Why didn't defense present that himself?
That gets into some of the presumptions that underline the federal and both state cases. There is an inherent presumption, both that juveniles are categorically immature, but also that juveniles even those who commit heinous crimes are capable of rehabilitation. I believe this court made clear in Majors that it's the state's burden in order to present sufficient evidence or overcome that presumption that a minimum sentence is warranted.
Expert testimony relies heavily on Apple's dissent in Majors. So are you asking us to overrule Majors to agree with you?
I don't believe that this court has to overrule Majors to agree. Apple's dissent highlights certain aspects of the categorical immature nature of juveniles.
Categorically, they are different. I think anyone who knows a child knows they're different that way. But my original question to you was, why wasn't it? Because it's not crystal clear whether or not an expert should be provided, and certainly who should provide it. Why didn't defense bring an expert up himself?
I don't believe, I'm not sure as to the attorney rationale for that. I'm unaware of why defense counsel did not do that. Based on the case law, it seems that the state has to overcome that presumption. So,
was it ever demanded by defense that state do that?
Not that I am aware of, but the case law does make clear that it is the state's, that the presumption of overcoming that minimum sentence lies with the state.
Not the part about the expert, though, correct?
Roby, my understanding of that more specifically dealt with the helpfulness that an expert could have in expounding upon those factors. There are certain elements that are, especially in cases such as this with murder, it's more helpful to have an expert there to help explain some of those underlying immature factors as well as the family circumstance.
Betty would agree. Of course, it would be more helpful. And there's lots of that permissive type language and encouraging language. Help persuade me, where are you hanging your hat that says it is, not just maybe, that it is the state's burden to actually not just suggest it, but to bring an expert to the table? Where is that strong language that you act as if it's implicit?
I'm sorry about that. The strong language that I'm referring to is that it's the state's burden to overcome that a juvenile would require a minimum sentence. I don't believe that this court has ever held that the state is required to bring an expert, but based upon that presumption, that's where that understanding is coming from. So I'm sorry if that was unclear. The underlying component of why it's the state's burden is because there are a series of presumptions that underline all of federal, and then there are more specific aspects to Iowa law as well. And so some of those presumptions include that, again, there's that central element of rehabilitation, that all juveniles are capable of that. And so having an expert come in to say that, well, no expert can provide testimony to say that, yes, this juvenile is in fact now mature. We've done a brain scan. We can determine that at this point they are fully mature. An expert can come in and testify that this juvenile falls within the regular bounds of juvenile immaturity or might demonstrate an exceptional maturity in certain regards. And that plays an important role with the sentencing aspect, because that categorical immaturity makes things like deterrence or retribution of much more limited importance in the juvenile sentencing context.
No other court has held that it is constitutionally required to present expert testimony before imposing a mandatory minimum for a juvenile.
Other court has found that. I would also like to point out there are other states that have found they have different, many other states have their own schemes for when to impose certain sentences. And so other states, for example, allow life without the possibility of parole for juveniles. But in order to do so, the state has to overcome a presumption beyond a reasonable doubt that that juvenile would qualify for that. And so in those instances, those states have said, we can't imagine an instance where an expert wouldn't be required. So,
Ms. Newell, here's the thing, where, you know, like in a medical malpractice case, and we're about to hear one of those next this morning, you have to have an expert because the ultimate question is sort of a medical one of medical negligence. Here, I've never been entirely clear what facts the trial judge is actually being asked to find when they sentence a juvenile to a mandatory minimum. It seems to me what our cases say is not so much a matter of specific findings as it is making sure that you consider the 5 factors. And do you really need an expert to consider the 5 factors? Didn't Judge Showers consider the 5 factors here?
Judge Showers did consider the 5 factors. These 5 factors are complicated in light of, again, the categorical determination that juveniles are different. And so in a highly individualized sentencing context, an expert can provide that highly individualized determination to help navigate that. Especially in cases like this, the answers might not be obvious why certain things happen the way that they did, and an expert can help the court.
And I agree an expert can be helpful, but this doesn't strike me like the medical malpractice situation where an expert is essential. It's more a helpfulness. And if it's helpful, then it's up to either the defense or the state to call one, right?
Yes and no. I think that, again, the burden is not on the defense to present that this is a juvenile that is immature. The burden is on the state to present evidence that that the juvenile is mature. In that context, that there is a presumption of inherent immaturity, and with that inherent immaturity comes this idea that juveniles are more able to rehabilitate. And so,
factors in this case did the district court need an expert to help them with?
I believe that the district court needed an expert to help. I think in part the juvenile family home environment, the district court acknowledged in the sentencing that there wasn't really any information about that. And so the district court did consider that factor, but there wasn't as much in-depth information that could have been adduced about that, as well as the immaturity and impetuosity, that first factor, that second factor.
Things that a district court sees generally when they're doing sentencing. I mean, district courts have a lot of experience in sentencing people. So why is it that we need to require an expert to help the district court with those?
So while the district court does have a lot of experience in sentencing adult offenders, many district courts do not have the experience with sentencing juvenile offenders. And so there is an additional layer of evidence that needs to be adduced to assist the district court in determining whether or not a minimum sentence is warranted. And that goes back to the state's burden to show that this is a juvenile that would warrant a punishment that would need retribution or deterrence. Because those sentencing rationales are so limited in scope when it comes to juveniles, having more additional information about the maturity itself would help a district court see that again, those traditional adult sentencing rationales would be appropriate.
Go ahead, Justice May.
With you, we would have to decide that the facts of a case could never just justify a mandatory minimum based on, for example, the simple facts of the case, the facts of the murder and the sort of behavior that we saw from the juvenile, that a judge would ordinarily be able to say, well, this is a, terribly heinous murder, and that on its own, the facts of the murder justify, as a matter of retribution, a mandatory minimum. Is that true?
I would say yes, and that's due in part to the nature of the juvenile sentencing hearings, that a certain one factor, the circumstances of the offense, cannot overwhelm the analysis as a whole. So they can be a large part of the analysis. In this case, it certainly was, but they cannot overwhelm them as a whole. And an expert does help prevent that from being the overwhelming factor.
Why is that the case? So when a district court judge is doing a sentencing, there are competing sentencing interests at stake. There's incapacitation, there's deterrence, there's retribution, there's rehabilitation. Why in a particular case can a district court judge determine that whatever the prospects of rehabilitation are for this particular offender, the facts and circumstances of the case warrant an X amount of punishment for other purposes, retributive purposes, incapacitation purposes? Those are totally different concepts. You can't really weigh them. As a district court judge, why couldn't Judge Showers make that determination that retribution outweighed any other interest in this case?
Because retribution has been found to be of limited use when it comes to juveniles in principal part. So juveniles, due to that immaturity, they're not thinking about the fact that they're not thinking through the consequences of their actions. They might choose an action to have a certain consequence, but they don't understand that they're choosing the rest of the consequences as well. And so there is an innate immaturity that prevents those other sentencing rationales from being of maximum use in the same way that it would be with an adult. Juveniles don't get to choose to be more biologically mature in a certain sense, and so those ideas that they're going to be deterred from certain actions only applies if they're actually thinking through their conduct, or in an adult context if we're punishing someone for not thinking through their conduct in a certain sense.
Just to follow your theory to its logical ends, so from your perspective, a district court judge would be unable to impose even a year mandatory minimum, even 6 months, or even a day before the parole board could release a juvenile. Is that correct?
Yes, but the parole board is not in practice going to release someone after a day. There are procedures that are put in place to ensure that the parole board can review whether or not someone has significantly reformed enough to be released.
Counsel, does it matter that the legislature didn't require any expert, even though it provided this list that the district court has to factor in?
I'm not sure that it does. And again, this goes to the state's burden of whether or not they can show that there's a juvenile that warrants an adult-like punishment. And so it's the state's burden to show that that juvenile would meet those certain standards to help with that. But I don't think that there's, I don't think that it cuts against the argument that the legislature doesn't require an expert.
Didn't receive an adult punishment. Isn't that right?
Right, that this, there is a significantly lessened, he didn't receive life without possibility of parole in this case.
If the legislature has taken into account our case law, they've created a two-tier sentencing scheme. Adults who commit murder in the first degree are punished one way. Juveniles are punished another way. The district court was afforded some discretion by statute and exercised it. Why isn't that enough to resolve this case?
To the first argument of my brief, that the judge in this case started from a presumption of a mandatory minimum.
Here's here quick, because your time's about up. The Lyle factors cannot be used for aggravating, but Chapter 902.1 has a longer list, which they can be aggravating. So how do we balance that?
That creates a difficult balance for district court judges. District court judges have a very difficult time with sentencing, and that adds to the confusion in a pretty significant way. In this case, the court has previously said that the circumstances of the offense cannot overwhelm the analysis.
But if we follow that logical argument, then aren't we ignoring the legislature's directive in 902.1?
I have not thought about that question. And I see that my time's about to be up. Is it okay if I respond? I don't believe that this court would not be following the directive. They can be considered as aggravating, or even certain parts of the fact can be considered more aggravating than others. But overall, the 5 factors need to be considered as mitigating. So there are certain facts where, of course, a judge is going to have a knee-jerk emotional response to hearing some of the facts, and that's, we don't ask judges to not be human. But the ultimate question is whether or not the mitigating factors are designed in part to make sure that the juvenile is being, the immaturity of the juvenile is considered throughout the full scope of the sentencing. So I see that my time is up.
Mr. Howe?
May it please the court, counsel. Good morning. This court should reject both of Miller's categorical challenges and affirm his sentence in its entirety. I'd like to begin with the categorical challenges because I think that's why we're here to talk today. Roby was wrong. Roby was wrong in a number of ways, and there's a number of paths this court can take in affirming Mr. Miller's sentence. The most straightforward one is to take Roby on its face and say that ordinarily experts are required, but not always. There are cases which fall outside that norm.
In your brief, you don't ask for us to overrule, but you just said it was wrongly decided. So where is it?
Disavow sections C and D of Roby. The reason I say that is because sections A and B are correct. Mandatory minimums, and I'll come back to that phrasing in a moment, minimums in Iowa are categorically permitted. They are what the legislature has permitted. They reflect a consensus of the states nationally, and this court's cases support them. Now, for purposes of C and D, that was this court's dicta in attempts to help district courts with the difficulty following Lyle and applying the 5 Miller factors. But again, we're not even in that context. We're talking about 902.1 and its 22-factor list. So we're already removed from the world in which Roby existed.
I was part of the court that decided Roby. I don't read it as requiring expert testimony, but if you want, to make more work for us and say that in order to win, we have to disavow parts of Roby, I'm interested in hearing from you.
From the dissent in Roby, I believe maybe Justice Zager wrote it, describing it as a de facto ban, and I was taking that on its face. Certainly.
As you know, I've written a lot of dissents, and you try and do the parade of horribles, and maybe not every float is in the parade, So it's, yeah.
Whether Roby lives or dies, it was wrongly decided. I'll leave it to this court, but I would recommend that you re-examine it because its ruling was unsound. There is no explanation in the opinion other than a cite to Lyle and a journal article discussing juvenile life without parole sentencing, a context in which after Sweet was never on the table for Mr. Miller or for Mr. Roby as reason for requiring an expert in every sentence in which a discretionary minimum would be imposed. And I would like to pause for a moment and invite the courts to reconsider its terminology. In a number of opinions, we've talked about mandatory minimums. Mandatory minimums historically have been when the legislature has deemed what the minimum term of incarceration could be, in which no suspension of a sentence could be permitted, in which the punishment is set. In Iowa, for every juvenile under 901-514, every minimum sentence is discretionary. The district court has the discretion to examine this defendant, this crime, his personal circumstances, and reach a sentence that fits. We should clarify our language and know when we're talking about mandatory minimums that apply across the board, regardless of the facts, that's maybe not fair. But when a district court has the discretion, certainly it can reach a sentence that is constitutionally permissible.
And not mandatory in this context.
The courts to use the term discretionary minimum, or if you are describing all minimums, use all minimums. But certainly this is not a mandatory minimum in this case.
Or affirmed a minimum sentence for juvenile offender without supporting expert testimony, or would this be the first?
A minimum sentence, no. In Harrison, he was sentenced to life with immediate parole eligibility. There was no expert, if I recall, in Harrison. It hasn't occurred yet, but the problems that arise from Roby are that the Court of Appeals is treating the requirement of they are treating it as a requirement, and that is not the case, or it should not be the case. And part of the reason also is that, as has been intimated by some of the questions today, and Justice May, your concurrence in Diaz's when you were with the Court of Appeals, is that in sentencing, judges are acting in their core function. It's not some foreign concept to them to apply circumstances to an individual to reach a sentence. They do it day in and day out. And it's not different with juveniles. Certainly, I agree.
Different. I mean, it's been different since we decided Lyle, really. Isn't it clear that, unlike in the usual sentencing situation where there's a presumption of regularity, the district court needs only cite a few considerations that led to that particular sentence, and that's good enough. Here, we do require that those 5 factors be addressed, don't we?
Forgive me, Justice Mansfield. I meant to continue, but your question is correct. Yes, they do need to consider them. But what I was attempting to say is that there are no mandatory sentences. For juveniles, every sentence is discretionary, and a district court can apply the 5 factors and reach a just sentence, or in this case, 22 factors, examining circumstances of the offense, the threat of the safety of the public, all of the concerns that we have, rehabilitation, deterrence, certainly incapacitation, and retribution. And when it comes to murder, I'm sorry, Chief Justice.
Talk about those considerations. When Judge Showers said evil does not have a birthday, was he properly weighing Miller's age and youth, circumstances of youth, in making that statement?
Your Honor, I think that sentence needs to be taken in its proper context. Judge Showers was deeply troubled by this case, and we can't know this from the record, but I suspect Mr. Miller's allocution was not particularly persuasive, nor is his statements in the PSI consistent with what actually occurred in this case. He was continuing to minimize what he had done. And in this case, the district court, as many district courts sentencing individuals do, had a frank discussion with him as to what he thought his crime was. It's not an impermissible presumption that a minimum was necessary. The facts convinced him what it was.
Maybe need to be taken into account in his minimization of his own. I mean, the fact that he isn't mature enough to recognize that, does that somehow weigh in how he can consider even that factor?
But again, we're already in a world far removed. Mr. Miller will never receive adult punishment for his crime. He will have the opportunity, even with this sentence, to demonstrate his rehabilitation.
5-year mandatory minimum. And I wanted you to comment on this statement from sentencing about the fact that he won't receive any of the services until he's close to being eligible for parole. And so if part of the issue is that juveniles are more rehabilitative, yet he's not going to get any services until he's near 50, is that a consideration that the district court should have considered in the sentence?
I'm not sure. The reason I say I'm not sure is because there was testimony from Mr. Heinriche from the Iowa Department of Corrections who talked about where Mr. Miller would be taken, the special circumstances for youthful offenders before they're transferred to, forgive me, but the primary DOC medical classification center, for where they will then determine what needs they have, where they will stay. Certainly, I think it's a thing the district court could consider. But again, I don't think it's something that required an expert, even though we actually had a person who works day in and day out dealing with individuals like Mr. Miller testify in the sentencing hearing.
You mentioned in your brief or that our cases talk about minimum sentences should be an uncommon result in a juvenile case. And I'm trying to think from the district court's point of view, how do you decide sort of, do you keep track of how many I've done, and I've done 8 and I haven't had a mandatory minimum, so it's time? Or how do we, is that loose language, or should have teeth in the process?
Candor, Justice May, I think Roby's invocation of that was erroneous. The original quote comes from Miller talking about juvenile life without parole sentences. Again, not something we're talking about here. And transplanting it into Roby to make any minimum sentence less likely was a mistake. So I would agree that it's loose language. I think a district court on these facts could find, and Judge Showers did find here, that this is an uncommon case. And it's uncommon because it's a case of premeditated murder that was planned for 2 weeks. They even planned and attempted to cover up the crime. And when Mr. Miller was beginning to be confronted with it, he started blaming innocent people for it, hoping that it would absolve him of liability. Again, I think this is factually the uncommon case, but the degree that Roby suggests that they should be an uncommon result, that part too should be disavowed.
Address, I think the chief asked this earlier, this tension between the 5 Miller factors and how they're supposed to be treated, and then the statutory factors, which seem to give the district court much more discretion in considering those. How should a district court resolve that tension?
Zarate for the answer there, because that was the first full challenge to 9021's additional sections. And the court did suggest that the circumstances can't overwhelm the analysis and remanded for resentencing for that purpose. I think that, in my opinion, because we are talking about a sentence that is categorically different than anything an adult would face, in which the legislature has weighed in and indicated what the circumstances are, we are beyond what Miller required. And so to the extent that the back half of Zarate remanded, I would not have. I would have affirmed that sentence.
Would it be permissible for the district court to say, I find your home and family circumstances were good, and that's an aggravating factor for this sentence? Is that permissible under Miller combined with the statute?
I believe so, just because we are so far removed from the core Miller context. I recognize that Zarate says that we should consider the 5 constitutional factors in the same manner that we would in Lyle, but I think we are removed from that context, and a district court could find them aggravating. This district court did not find his home circumstances aggravating, but yes, sorry. The answer to your question is yes, a district court could find them aggravating.
I agree with you. I mean, as you know, I joined the dissent in Roby, and I thought Justice Sager did a pretty good job there. And I had some concerns about Roby, but without kind of overturning this whole apple cart. I mean, isn't it possible to just say you need to consider these 5 factors? They can be presented factually. You can have expert testimony if either party wants to, and then the court, after considering and discussing the 5 factors, can also introduce the other factors from the legislature and render a sentence.
Justice Mansfield, and I wrote my brief respecting the fact that this court might not have an appetite for reviewing Roby, but if push comes to shove, Roby is wrongly decided and should be disavowed. Now, to the extent to your question, yes, you could affirm this case with Roby still alive, but it's not necessary. And there are, frankly, if we look at the 4 interests in determining whether stare decisis should prevent us from, none of them are in play. The reasoning that I'm challenging has next to no authority behind it other than a misattribution to Lyle, a journal article. Reliance interests aren't.
Your issue is not really just with Roby. I mean, you don't like Zarate either, and I think you probably don't like Lyle. I mean, I was on the opposite side, on the losing side of this debate, and I think there's a fundamental conceptual problem. If you're talking about life without parole, the Supreme Court says, well, you can only do that if the court makes a determination that the person is essentially incorrigible. It's not a possibility of rehabilitation. Okay, that's a standard that a district judge can understand and can apply. When you're talking about these mandatory minimums, there's no real standard for the court to apply in deciding whether to grant a mandatory minimum and how long it should be. It's simply, I think that leads to this loose language that you've described in Roby and some of the other cases. I think what we simply should do is clarify that there isn't a standard other than normal sentencing, but you need to consider the 5 factors.
Do that. And to be clear, Justice McDermott, as you brought up, the legislature has stepped in after this court's cases to provide guidance to district courts, especially in this context specifically, what circumstances and factors a district court should be looking at when ordering a sentence. I would also just note that I find the request for a categorical requirement of an expert before a minimum sentence can be imposed is a little difficult to square with Mr. Miller's other request, which is that no minimums ever, because no expert can actually opine on the issue in question, and even then any day beyond it would be cruel and unusual punishment. There's no way to square those two things. And I agree, experts aren't perfect, but they can be helpful, and parties can choose to bring them, but certainly they're not constitutionally required.
Why the prosecutor in this case did not call an expert?
And even if I did, it wouldn't be in the record, and if it's not in the record, it's not for our purposes.
Completed your discussion of stare decisis. You said that Roby was poorly reasoned and there's no reliance interest.
Difficult to work with. Its rules were, again, taking the dissent on its face, intended to be a de facto ban that never arrived. And finally, in terms of subsequent factual and legal developments, this court's subsequent jurisprudence does tell district courts that they should look at the circumstances of the crime. Goodwin and Majors both told our district courts, when heinous crimes are involved, you should look at how heinous they are. You shouldn't be blind to that. And again, I think those developments also suggest that our district courts should have the discretion to enter sentences, even without the assistance of an expert. I am out of time. I thank you for your attention, and again, the state would ask that this court reject both of Miller's categorical challenges and affirm his sentence in its entirety. Thank you.
I'd like to start out with another comment that the district court made when sentencing Mr. Miller, not just the evil does not have a birthday, but the district court did start from a presumption of a mandatory minimum, and that statement was evident when the district court told Mr. Miller that he was very fortunate that the state of Iowa does not allow the option of life without the possibility of parole, because that would have been a serious consideration for the court if it had that option.
I mean, back up on that. Fingers on it right away, but all those comments were made by Judge Showers well after, I think, 4 witnesses by the state, and allocution, everything else, review of the PSI, and after all the evidence for the hearing was in. Isn't that true?
Is true, but I don't think that takes away from the severity of that statement. Judge Showers, in essence, said, if I could impose what is now considered an unconstitutional and illegal sentence, I really would have thought about it.
He'd heard the evidence at that point, and isn't it very likely, because I could tell from the transcript, I think he had his thoughts probably sketched out, because it was very similar to what was in the written order. He verbalized it and it was written. So when I used to be a trial court judge and I had to rule, sometimes I'd rule from the bench, and I didn't have to actually give all of my reasons. In this case, it's different, but sometimes I would, just to help the parties understand. But a lot of times judges enter orders and don't give you that thought process. So why is it wrong for Showers to be saying perhaps maybe his conclusion, but then it's based on the evidence that's been presented? What's wrong with that?
Nothing wrong with a judge issuing a sentence based upon the testimony given at a sentencing hearing. The issue in this case is that statement, along with the other statements about evil does not have a birthday, tend to show a much more, it's not starting from a presumption that a minimum sentence wouldn't be warranted, and it's not starting from a presumption that a juvenile is capable of rehabilitation in some ways. The nature of the statements was so, the nature of the statements themselves were so.
Said he started with that presumption. I'm looking at the very beginning, it's transcript page 160, when the court starts talking at the end of everything being presented. And he says, Mr. Miller, I've considered all the sentencing options provided for in chapters such and such. And my judgment relative to sentence is based on the 25 factors I'm required to consider. So why is that a violation of what you're saying he was supposed to do? That doesn't seem like a presumption to me. That tells me I'm going through this checklist and I'm going to tell you why I'm going to do what I'm going to do. How is that a presumption?
The presumption, well, that initial statement does not indicate that there's necessarily a presumption there. Further on in his statements during sentencing, it does become clear that he did have a presumption of a much higher sentence.
That he wanted to do a much higher sentence after hearing everything he heard.
I'm not going to speculate, I guess, on whether or not, what.
That he had already made a decision. You don't know what was in his head. It was after everything was said that he made that comment, after all the evidence. How can we be so sure that the first part of what he said is incorrect and only rely on what he said later?
I'm not sure that it's not saying that he wasn't, there's not like a doubt about the first part of his statement, I guess, but it's indicating in any way, shape, or form that if I had the option to impose what is now considered an unconstitutional sentence, I would have seriously considered it. That is the issue with that statement, that is.
With the chief, I don't see the problem with this.
Have. That means, gosh, if only I could. Isn't that an outward acknowledgement? I can't. But if I could.
It seems very clear that Judge Showers considered the evidence and what was presented at the sentencing hearing and the PSI. All of that. I look through the 5 factors and, I've thought hard about it. I don't see any of the 5 that really help this particular defendant. Do you? Is there any you think help?
The inherent nature of the district court did find that Mr. Miller was capable of rehabilitation and found that he had started along his rehabilitation journey. And that capability to rehabilitate is a very strong mitigating factor that is present throughout all juvenile court cases. The impetuosity, impulsivity, and risk-taking of juveniles is also a strong consideration as a mitigating factor in this case. I see that my time is up. If there are no further questions, Mr. Miller requests that this court vacate his sentence and remand his case to the lower court for a new sentencing hearing.
Case of State versus Willard Miller is hereby submitted. We will have a brief transition here before our next oral argument, which is SK versus Obstetrics and Gynecology of Iowa City.